Rule 8. What are ultimate facts? The facts essential to a claim or defense. A fact is essential if it cannot be stricken out without leaving the statement of the cause of action or the defense insufficient. How shall the ultimate facts be stated in a pleading? Every pleading shall contain in a methodical and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence on which the party pleading relies for his claim or defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him shall be clearly and concisely stated. How may alternative causes of action or defenses be pleaded? A party may set forth two or more statements of a claim or defense alternately or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. That is Section 2, Rule 2. In alternative causes of action or defense, what is the effect of the insufficiency of one of the alternatives? In such a case, as long as one of the alternative statements, if made independently, would be sufficient, the pleading is not rendered insufficient by the insufficiency of the other alternative. In pleading alternative causes of action or defenses, is it required that the causes of action or defenses be consistent with each other? No. The causes of action or defenses alleged may be inconsistent with each other, provided that each cause of action or defense be consistent in itself. Bucklion versus Court of Appeals, GR number 89132, 26 February 1990. Plaintiff sued defendant for collection of $1 million based on the latter's promissory note. The complaint alleges, among others, 1. Defendant borrowed $1 million from plaintiff as evidenced by a duly executed promissory note. Number 2. The promissory note reads, Makati, Philippines, December 30, 2014. For value received from plaintiff, defendant promises to pay plaintiff $1 million 12 months from the above indicated date without necessity of demand. Signed, defendant. A copy of the promissory note is attached as Annex A. Defendant, in his verified answer, alleged, among others, 1. Defendant specifically denies the allegation in paragraphs 1 and 2 of the complaint. The truth being defendant did not execute any promissory note in favor of plaintiff, or number 2, defendant has paid the $1 million claimed in the promissory note Annex A of the complaint as evidenced by an acknowledgement receipt duly executed by plaintiff on January 30, 2015 in Manila with his spouse signing as witness. A copy of the acknowledgement receipt is attached as Annex 1 hereof. Plaintiff filed a motion for judgment on the pleadings on the ground that defendant's answer failed to tender an issue, as the allegations therein on his defenses are sham for being inconsistent. Hence, no defense at all. Defendant filed an opposition claiming his answer tendered an issue. Is judgment on the pleadings proper? That is asked in the bar, 2015. No, judgment on the pleadings is not proper. Under Section 2 of Rule 8, a party may set forth two or more statements of a defense alternatively or hypothetically. The Supreme Court has held that inconsistent defenses may be pleaded alternatively or hypothetically, provided that each defense is consistent with itself. Same case, Bucklion versus Court of Appeals, February 26, 1990. Hence, plaintiff's contention that defendant's answer failed to tender an issue as his defenses are sham for being inconsistent is without merit. Q. In an action to recover a parcel of land, the intervenors claim to be the absolute owners thereof and ask that they be placed in possession of the property. But defendants maintain that they had absolute title on the land and filed a counterclaim for injunction against plaintiff and intervenors. Judgment was rendered for the defendants. In a subsequent action, the interveners claimed from the defendants the expenses they had incurred in clearing and cultivating the parcel of land and planting coconut and other fruit bearing trees thereon. The defendants, in their answer, pleaded that the plaintiff's claim was a compulsory counterclaim that should have been set up in the former action as against the counterclaim for injunction filed by the defendants. The plaintiffs replied that they could not have set up in the former case such counterclaim for improvements because it would have been inconsistent with and would have weakened their claim for title to the land. Is the plaintiff's contention meritorious? The answer is no. Under Section 2, Rule 8, a party may set forth two or more statements of a claim or defense or hypothetically, either in one cause of action or defense or in separate causes of action or defenses. Hence, the plaintiff and interveners in the former case could have set up the claim that they were entitled to the parcel of land, and alternatively, that assuming hypothetically that they were not entitled to the land, at least they are entitled as possessors in good faith to the coconut and other fruit bearing trees planted by them in the land and their fruits or their value. Their failure to set up that alternative claim in the former case bars it forever. Camara versus Aguilar, 50 OG, 1549, 12 March 1954. Q. Petitioners filed with the CFI of Cebu an action for recovery of land against the private respondents. The private respondents filed an answer raising the defense of their ownership. The CFI decided in favor of the private respondents, but on appeal, the Court of Appeals reversed and decided in favor of the petitioners, declaring them as the owners of the land and ordering the private respondents to vacate the premises. In the body of its decision, the Court of Appeals stated that there was no fraud or bad faith on the part of the private respondents. The Court of Appeals judgment became final and executory. The petitioners moved for the execution of the judgment before the CFI. This was opposed by the private respondents on the ground that a hearing supplementary to execution should be conducted to allow them to present evidence to prove that they are builders in good faith and to prove the value of the improvements. The petitioners argued that the private respondents should have set up their claim for reimbursement in the action for recovery. The Court of Appeals allowed the private respondents to present such evidence, stating that the private respondents could not have presented such evidence in the trial court since it would be inconsistent with their defense of ownership. Is the reason cited by the CA for allowing the private respondents to present evidence tenable? The answer is still no. The Court of Appeals statement that private respondents could not have raised the counterclaim for reimbursement of the value of the improvements as it would run counter to their defense of ownership is without merit. Under Section 2, Rule 8, a party may set forth two or more statements of a defense, alternatively or hypothetically. Inconsistent defenses may be pleaded alternatively or hypothetically, provided that each defense is consistent with itself. Not having been set up, the counterclaim is barred under Section 2, Rule 9. The same case, Bookline versus Court of Appeals. Same facts as the previous question. Letter A. Should the CFI grant the opposition of the private respondents to petitioner's motion for execution? Letter B. May the private respondents file a separate action to recover the value of the improvements introduced by them? Answer to letter A is no. Once a decision has become final and executory, the only jurisdiction left with the court is to order its execution. To allow the supplemental hearing would be to amend or alter a final and executory order. Answer to letter B, no. Under Section 2, Rule 9, a compulsory counterclaim that setup is deemed barred. The claim for reimbursement of the value of the improvements is in the nature of a compulsory counterclaim since it is connected with the transaction or occurrence constituting the subject matter of the petitioner's claim. Hence, it should have been set up as a compulsory counterclaim in the action filed by petitioners against the private respondents. Q. What facts may be averred generally in a pleading? Letter A. Performance or occurrence of conditions precedent. Letter B, malice, intent, knowledge, or other condition of the mind of a person, or MICO. What facts must be averred with particularity? Letter A, in all averments of fraud or mistake, the circumstances constituting fraud or mistake must be stated with particularity. That is Section 5 of Rule 8. Letter B, facts showing the capacity of a person to sue or be sued, or the authority of a party to sue or be sued in a representative capacity, or the legal existence of an organized association of persons must be averred. Section 4, Rule 8. Letter C, a party desiring to raise an issue as to the legal existence of any party or the capacity of any party to sue or be sued in a representative capacity shall do so by special denial, which shall include such supporting particulars as are peculiarly within the pleader's knowledge. Q. Lirio and Semicon Integrated Electronics Corporation, or Semicon, entered into a lease contract covering Lirio's properties. Villalon, who was then Semicon's president and chairman of the board, represented the lessee corporation in the lease contract. Prior to the expiration of the lease, Semicon terminated the contract and allegedly left unpaid rentals, damages, and interest. Lirio demanded payment, but Semicon and Villalon failed to pay. Lirio thus filed a complaint for sum of money against Semicon and Villalon. In his complaint, Lirio alleged that Semicon and Villalon unjustly pre-terminated the lease and failed to pay the unpaid rentals despite demand. Lirio alleged also in his complaint that Villalon fraudulently and surreptitiously removed Semicon's equipment, merchandise, and other effects from the leased premises, preventing him to exercise his right, among others, to take inventories of these effects, merchandise, and equipment. Villalon filed a motion to dismiss on the ground that the complaint failed to state a cause of action against him. He argued that he is not a real party in interest, as he is merely an officer of Semicon. Villalon further contended that there was no competent allegation in the complaint about any supposed wrongdoing on his part to warrant his inclusion as a party defendant. The RTC granted Villalon's motion to dismiss. It held that under the theory of separate corporate entity, the action should be limited against Semicon, the lessee. It cannot be expanded against Villalon, a mere corporate officer. The Court of Appeals reversed the RTC, holding that the allegation of fraud against Villalon placed the case within the doctrine of piercing the veil of corporation fiction and thus stated a cause of action against Villalon. Did the Court of Appeals correctly reverse the RTC's dismissal order? The answer is no. Section 5, Rule 8 requires that in all averments of fraud, the circumstances constituting fraud must be stated with particularity. Here, Lirio's mere invocation of the words surreptitiously and fraudulently does not make the allegation particular without specifying the circumstances of Villalon's commission and employment of fraud, and without delineating why it was fraudulent for him to remove Semicon's properties in the first place. The allegation of fraud would have been averred with particularity had Lirio alleged, for example, that Villalon removed the equipment under the false pretense that they needed repair and refurbishing, with the equipment were never returned, or that Villalon removed the merchandise because Semicon needed to sell them in exchange for new supplies, but no new supplies were bought. No such allegation was ever made. Thus, the RTC could not have properly ruled on whether there was a need to pierce the veil of corporate entity, precisely because the complaint failed to state with particularity how Villalon committed and employed fraud. Hence, the complaint failed to state a cause of action against Villalon. Villalon versus Lirio, August 3, 2015. Q. The complaint alleged that the defendant acted in bad faith. arbitrarily, illegally, wrongfully, and in violation of law. However, it did not contain any averments of facts showing that defendants' acts were done in the manner alleged. Does the complaint state a cause of action? Yes, malice, intent, knowledge, or other condition of the mind, MICO, may be averred generally. Actionable document. Q. What is an actionable document? An actionable document is a written instrument or document on which an action or defense is based upon. Section 7, Rule 8. Give examples of actionable documents. P files an action to collect a loan from D. D files an answer raising the defense of payment. The promissory note signed by D evidencing the loan is an actionable document for plaintiff. On the other hand, a receipt showing payment of the loan is an actionable document for the defendant. What is the requirement regarding an actionable document? They shall be set forth in the pleading. How is an actionable document set forth in a pleading? The substance of the actionable document shall be set forth in the pleading, and the original or a copy thereof shall be attached to the pleading as an exhibit, which shall be deemed to be a part of the pleading. Section 7, Rule 8. Should an actionable document be attached to the pleading? Would a failure to do so result in the dismissal of the action? Yes, the actionable document shall be attached to the pleading as required under Section 7, Rule 8. However, a failure to so attach or set forth should not result in the outright dismissal of the complaint. Cahin Everett Forwarding Company versus Tokyo Marine Malayan Insurance Company, January 28, 2019. Judge Justice Reyes. The court should simply order the plaintiff to attach or set forth the actionable document. Q. The insurer paid the shipper insured upon loss of the cargo while in possession of the freight forwarder. Having been subrogated to the rights to the insurer sued the freight forwarder. Judgment rendered in favor of the insurer. On appeal, the freight forwarder contends that the trial court shall not have considered or should not have considered in evidence the insurance policy, since being an actionable document, it should have been attached or set forth in the complaint. Is the contention correct? The answer is no. Failure to attach or set forth actionable document does not preclude its subsequent offer in evidence. There is no specific provision in the rules of court which prohibits the admission in evidence of an actionable document in the event a party fails to comply with the requirements of the rule on actionable documents under Section 7, Rule 8. If the adverse party wants to contest the genuineness and due execution of an actionable document, how shall he do so? The adverse party shall specifically deny under oath the genuineness and due execution of the actionable document and set forth what he claims to be the facts. Section 8, Rule 8. Otherwise, the genuineness and due execution of the actionable document shall be deemed admitted. What specific facts are deemed included within the admission by the adverse party of the genuineness and due execution of an actionable document? Number 1, that the party whose signature it bears signed it. Number 2, that if signed by another, it was signed for the adverse party and with his authority. Number 3, that at the time it was signed, it was in words and figures exactly as set out in the pleading of the party relying upon it. Number 4, that the document was duly delivered. And number 5, that any formal requisites of law, such as seal, acknowledgement, or revenue stamp, which it lacks, are waived by him. Hibbert versus Rode, 32 Phil 476. Hence, the following defenses, among others, are barred by the implied admission. 1. Forgery. 2. The agent signing was not authorized or exceeded his authority. 3. The party signing the document signed it in the same other capacity than that alleged in the pleading. 4. That the document was never delivered. 5. Lack of documentary stamps. Filipinas Textile Mills, versus State Investment House, November 12, 2003. Q. P filed an action for collection of loan against D. P attached to the complaint a copy of the promissory note evidencing the loan signed by D. D filed an unsworn answer specifically denying that he signed the note. After the presentation of his testimonial evidence, P rested his case, forgetting to formally offer in evidence the promissory note. The court rendered judgment in P's favor, taking into consideration the promissory note. On appeal, D assigns as error the court's taking into consideration the promissory note, although it was not formally offered in evidence. Is D's assignment of error meritorious? The answer is no. D's failure to specifically deny under oath the promissory note, which was an actionable document, resulted in D's implied admission of its genuineness and due execution. The same is a judicial admission and hence does not require proof pursuant to Section 4, Rule 129. In an action for collection of $2 million, plaintiff bank alleged that defendant Oriental Textile Mills, Incorporated, for valuable consideration, executed in favor of the bank a promissory note for said amount. A copy of the note being attached to the complaint. Defendant filed an answer to the complaint denying liability and alleging that the signatory Jesus Lim had no authority to negotiate and obtain a loan in its behalf, nor to sign the promissory note. The answer was not verified. During the trial, defendant sought to introduce evidence to show that Jesus Lim was not authorized to enter into the transaction and to sign the promissory note for and in behalf of the defendant corporation. Plaintiff objected to such evidence, claiming that Lim's authority had been admitted by defendant's failure to verify the answer. The judge sustained the objection. Was the ruling correct? Asked in 1991 bar. Yes, the judge's ruling sustaining the objection was correct. The Supreme Court has held that the implied admission of the actionable document's genuineness and due execution includes an admission that the agent signing the same was duly authorized by the adverse party. Hence, the defense that the agent signing the same was not authorized by the principal is barred by the implied admission. Hebert versus Rode, 3rd to Phil 476. P. purportedly sold a parcel of land to D. Later, P claimed that what he signed was a document captioned lease contract and not a deed of sale. P then filed a complaint against D and M, to whom D sold the property. In their answer, D and M attached the purported deed of sale. P did not file a reply specifically denying under oath the deed of sale. During the trial, can P be allowed to testify that what he actually signed was a lease contract and not the deed of sale? Yes, failure to deny the genuineness and due execution of an actionable document does not preclude a party from arguing against it by evidence of fraud, mistake, compromise, payment, statute of limitations, estoppel, and want of consideration. Akabal versus Akabal, March 31, 2005. Here, P's evidence to the effect that what he actually signed was a lease contract and not a deed of sale is evidence of mistake or fraud. In his answer to the complaint, Mario Reyes alleged that he does not owe Norma Alahar any sum of money and that he executed the promissory note only to enable Alahar to show the same to her husband to explain the disappearance of the amount from the conjugal funds as Norma Alahar lost the same in the casino. The answer is not verified. At the trial, the lawyer of Norma Alahar objected to the testimony of Mario Reyes as to his accommodation story because, as the answer is not verified, he is deemed to have admitted the genuineness and the due execution of the promissory note. Decide on the objection with reason. Objection overruled. Failure to deny the genuineness and due execution of an actionable document does not preclude a party from arguing against it by evidence of want of consideration. A cabal versus a cabal. Here, Mario Reyes defends that he was only an accommodation party is a defense of want of consideration. Plaintiff filed an action to recover a parcel of land against the defendants. Attached to the complaint is a copy of the deed of sale executed by the defendant's father in favor of the plaintiff. The defendant specifically denied, but not under oath, the deed of sale. At the trial of the case, defendants sought to present an expert witness to testify that the signature of the seller in the deed of sale is a forgery. Plaintiffs objected to the presentation of the witness, saying that the defendants impliedly admitted the genuineness and due execution of the deed of sale when they failed to specifically deny it under oath. How should the trial court rule on the objection? The trial court should overrule the objection. Under Section 8, Rule 8, the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument. Here, the defendants were not parties to the deed of sale. See Toribio versus Bidin. Note, although the requirement of an oath does not apply, the adverse party should still specifically deny the actionable document and set forth what he claims to be the facts. Pedro filed an action for recovery of land against Ding. Ding filed an action in which he raised the defense that he was the owner of the land that Pedro's late father, Frondo, had sold the land to him. Ding attached to his answer a copy of the deed of sale over the subject land, purportedly executed by Frondo in favor of Ding. Pedro did not file a reply. During the trial, may Pedro be allowed to prove over the relevant objection that his father's signature to the deed of sale was a forgery? The answer is no. Although the requirement of an oath does not apply to Pedro since he is not a party to the deed of sale, nevertheless, Pedro should still specifically deny the actionable document, that is, the deed of sale, and set forth what he claims to be the facts. Since he failed to do so, Pedro is deemed to have admitted the genuineness and due execution of the deed of sale, and he is thus precluded from proving that his father's signature thereon was forged. Q. A filed suit against B and C for the recovery of personal property which, according to the complaint, had been sold to him by the defendant's father during the latter's lifetime under a document entitled Bill of Sale. The substance of the bill was pleaded in the complaint, and a copy thereof was attached to the complaint as an exhibit. B and C filed an answer which disclaimed knowledge or information about the bill of sale and averred that the signature thereon, allegedly belonging to their father, appears to be a forgery. At the trial of the case, B and C commenced, through counsel and by means of an expert witness, to adduce evidence to prove that the seller's signature was a forgery. A objected, saying that the genuineness and the due execution of the bill of the sale was deemed admitted because the answer was unverified as a matter of law, inasmuch as the verification was made only on the express basis of best information and belief. Resolve the objection with reason. Objection overruled. Under Section 8, Rule 8, the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument. Here, the defendants B and C were clearly not parties to the bill of sale. Hence, there was no need for their answer to be verified or under oath. The disclaimer by B and C of knowledge or information about the bill of sale and their averment that the signature purporting to be their father's appears to have been forged may be considered as a specific denial under the third sentence of Section 10, Rule 8. Y leased a warehouse to C for 2 years, evidenced by a written lease contract. As Z refused to vacate after the expiration of the lease, X's only son, Y, who had died, filed action to recover possession, alleging that although Z sought renewal of the lease contract, This was denied by Y in his lifetime, shown by a copy of a letter reply signed by him addressed to C, attached to the complaint as Annex A. In his answer, C asserted that the contract was verbally renewed, but he failed to deny under oath the due execution and authenticity of Annex A. During the trial, Z's testimony showing Y's signature on Annex A to be a forgery is vehemently objected to on the ground that the absence of a sworn denial in the answer constitute an implied admission of the due execution and authenticity of Annex A, an actionable document. Resolve the objection with reason. Objection overruled. The rule on implied admission under Section 7 and 8 of Rule 8 applies only to an actionable document, that is, a written instrument or document upon which an action or defense is based. Here, the action of X was based upon the written lease contract and not upon the letter reply, which is merely an evidentiary document. Even assuming that the letter reply was an actionable document, the requirement of an oath does not apply when the adverse party does not appear to be a party to the instrument. Section 8, Rule 8. Here, C was not a party to the letter reply, which was unilaterally prepared by Y. Respondent sold and delivered fabricated steel products to Petitioner Construction Corporation under a sales contract. Petitioner failed to pay, so respondent sued petitioner for the price of the sale. Attached to the complaint were charge invoices issued by respondent to petitioner, which indicated the items sold and delivered to petitioner. Petitioner filed an unsworn answer. Did petitioner admit the genuineness and due execution of the charge invoice by its failure to specifically deny them under oath? No. Under Section 7, Rule 8, a document is actionable when an action or defense is grounded upon such written instrument or document. Here, the charge invoices are not actionable documents per se, as these only provide details on the alleged transactions. These documents need not be attached to or stated in the complaint, as these are evidentiary in nature. In fact, respondents' cause of action is not based on these documents but on the contract of sale between the parties. Asian Construction and Development Corporation versus Mendoza, 27 June 2012. Q. Action by BP Oil to recover value of petroleum products delivered to Total Distribution under an agency agreement executed between the two. The complaint of BP Oil includes as an annex a letter from BP Oil to Total, which states the value of stocks of unsold lubricants. This letter was not specifically denied under oath by Total. Is Total deemed to have admitted the genuineness of the letter? No. The letter is not an actionable document but an evidentiary document. BPO's action was based on the agency agreement, not the letter. Hence, Total failure to put its denial under oath will not amount to an implied admission. BP Oil versus Total Distribution, February 6, 2017. Young Builders Corporation, or YBC, sued Benson Industries, or BBII, for payment under a construction contract where YBC would construct a building for BII. In its complaint, YBC averred that it had accomplished work on the building in the amount of 54 million, of which BII had paid only 40 million. Attached to the complaint was a copy of the accomplishment billing. During the trial, YBC failed to authenticate the accomplishment billing. Thus, the court ruled in favor of BII. On appeal, YBC contends that there was no need to authenticate the accomplishment billing since BII failed to specifically deny it under oath and thus impliedly admitted its genuineness and due execution. Is YBC's contention meritorious? The answer is no. The actionable document, which was the basis of YBC's action, is the construction contract between the parties. The accomplishment billing is merely an evidentiary document, thus the implied admission rule does not apply, and hence YBC needs to authenticate the accomplishment billing. Young Builders Corporation versus Benson Industries, June 2019. Suppose the defendant denies under oath the due execution of an actionable document attached to plaintiff's complaint under Rule 8, Rules of Court. However, before the trial, plaintiff serves on defendant a request for admission under Rule 26 of the Rules of Court, asking him to admit the genuineness of the same actionable document described in and exhibited with the request, but the latter fails to serve on the plaintiff within 15 days a sworn statement denying specifically the authenticity of the document. As far as the probative value is concerned, which will prevail? The sworn denial in the answer or the implied admission arising from defendant's failure to serve a sworn denial to the request for admission? It is the sworn denial in the answer which will prevail. A request for admission is not proper where the subject matter thereof is the same as the alleged in the requesting party's complaint for which the requested party had already denied in his answer. A party should not be required to make a second denial of those allegations already denied in his answer to the complaint. Lanyada versus CA, GR 102390, February of 2002. P filed a verified complaint against D seeking to recover a parcel of land. In the complaint of P, alleged that he never sold the land to D, but D took possession under a false claim of ownership. D filed an answer to which he attached a copy of a deed of sale between him and P over the land. P did not specifically deny under oath the genuineness and due execution of the deed of sale. Was there an implied admission under Section 8, Rule 8? No. The verified complaint with specific allegation that P never sold the land to D was a substantial traversal of the actionable document. Toribio versus Bidin. Manuel filed a verified complaint to annul a deed of sale over community property which his wife Martha had executed in favor of Titan Corporation. Manuel alleged that the sale was made without his knowledge and consent. In its answer, Titan Corporation attached a special power of attorney purportedly executed by Manuel in favor of his wife, authorizing her to sell the land. Manuel filed a reply which was not under oath, alleging that his signature to the SPA was forged. May Manuel prove that his signature to the SPA was forged? Yes. The allegation in the verified complaint that Manuel did not know or consent to the sale of the land put Titan Corporation on adequate notice that it would be called upon during the trial to prove the genuineness and due execution of the SPA. Hence, the implied admission rule under Section 8, Rule 8 does not apply. Titan Construction Corporation versus David, GR number 169548. Citing Toribio versus Bidin. It may also be said that the complaint, which was verified and which alleged that Manuel did not consent or know about the sale, was a substantial traversal of the SPA's genuineness and due execution. P filed a complaint for collection of $500,000 against D. P attached a copy of the promissory note for $500,000 to the complaint. D filed an answer which was not under oath or verified, in which he alleged in the main that he had already paid the $500,000. P offered in evidence the copy of the promissory note without accounting and for the non-production of the original. D objected to the offer on the ground that it violates the best evidence rule since only a copy and not the original was presented. Should the trial court sustain the objection? No. The trial court should not sustain the objection. The Supreme Court has held in Gao versus Chua, GR 160855, April 16, 2008, that a party who impliedly admits the genuineness and due execution of a document by failing to contest it in accordance with Section 8, Rule 8, cannot object to the presentation of a copy. Here, D failed to specifically deny under oath the promissory note since his answer was not verified or under oath. Hence, D impliedly admitted the genuineness and the due execution of the promissory note and cannot object to the presentation of a copy thereof rather than the original. Petitioner Conception Chua and respondent Sui Ben Chua are the children of the late Chua Chin. Upon the demise of Chua Chin, his spouse and his children executed a deed of partition wherein they waived their shares over the Hagone lumber in favor of their co-heir Chua Siok Han. Chua Siok Han then sold the Hagone lumber to respondent. Later, respondent delivered a check for 200,000 to petitioner, which the latter encashed. Subsequently, respondent sued petitioner to collect on the 200,000 which the respondent alleges was a loan. In her answer with counterclaim, petitioner alleged that the 200,000 was an advance on her share in Hagone lumber and counterclaimed for accounting and delivery of her share. Respondent filed an answer to the counterclaim wherein he alleged that petitioner no longer had any interest in Hagone lumber because of the execution of the deed of partition and that he is now the owner of the Hagone lumber by virtue of a deed of sale executed in his favor by Tua Shok Han. Respondent annexed copies of the deed of partition and of sale to his answer to the counterclaim. Petitioner filed a reply and countered that the deed of partition and the deed of sale were not true and valid agreements and did not express the true intention of the parties, and that the deeds were only temporary paper arrangements executed upon advice of counsel until all heirs could reach a final agreement. After trial, the court ruled in favor of respondent. Petitioner contended that it was error for the trial court to admit mere copies of the deed of partition and the deed of sale in violation of the best evidence rule. Is the petitioner's contention correct? Answer is no. The petitioner's contention is not correct. The Supreme Court has held in Gao versus Chua, GR 160855, April 16, 2008, that production of the original may be dispensed with in the trial court's discretion whenever the opponent does not bona fide dispute the contents of the documents and no other useful purpose will be served by the requiring production or by requiring production. Here, there was no dispute as to the terms of other or either deed. Hence, the RTC correctly admitted the photocopies of evidence. Petitioner admitted signing the deed of partition. As for the deed of sale, petitioner, in effect, admitted the genuineness and due execution of the deed of sale when she failed to specifically deny it pursuant to Section 8, Rule 8. The petitioner did not contest the contents of the deeds, but simply alleged that there was a contemporaneous agreement that the transfer of Hagone lumber to Chua Siok Han was only temporary. Note, although petitioner was not a party to the deed of sale between Chua Siok Han and respondent, and therefore is not required to deny it under oath, she must still specifically deny its genuineness and due execution. This petitioner failed to do so, so she impliedly admitted the same pursuant to Section 8, Rule 8. State Investment House, SIHI, filed an action for collection against Filipinas Textile Mills, Philtex. In its complaint, SIHI alleged that Philtex applied with SIHI for the issuance of letters of credit to finance the purchase of raw materials from various suppliers and that SIHI issued the letters of credit but Philtex did not pay the loan it had incurred from SIHI in relation to the letters of credit. The letters of credit were attached to the complaint. Philtex filed an unsworn answer denying liability. Judgment was rendered in favor of SIHI. Philtex contends that the trial court erred in admitting in evidence the letters of credit since the documentary stamps were not affixed thereto and cancelled, and hence the letters of credit cannot be used in evidence pursuant to Section 201 of the National Internal Revenue Code. Is Philtex's contention valid? No. Since Philtex failed to specifically deny under oath the letters of credit, it is deemed to have impliedly admitted the genuineness and due execution of the same. Such implied admission includes the waiver of the objection to the lack of documentary stamps, Filipinas Textiles Mills versus State Investment House, GR 119800. Plaintiff filed an action to annul a deed of sale against the defendant on the ground that he had not made any sale thereof. The defendant filed an answer to which he attached a copy of a deed of sale purportedly executed by plaintiff. Plaintiff did not file a reply under oath. During the trial, plaintiff presented without objection an expert witness who testified that the plaintiff's signature on the deed of sale was forged. May the court take into account the testimony of the expert witness in deciding the case? Answer is yes. While the plaintiff impliedly admitted the genuineness and due execution of the deed of sale, when he did not specifically deny it under oath and set forth what he claims to be the facts, the benefits of the implied admission were lost by the defendant when he failed to timely object to evidence challenging the genuineness and due execution of the actionable document. Ko versus Ong Shak Ko, 36 Phil 185, Titan Construction Corporation versus David. What are the three modes of specific denial? First mode, the defendant must specify each material allegation of facts, the truth of which he does not admit, and whenever practicable, set forth the substance of the matters upon which he relies to support his denial. Second mode, where a defendant desires to deny only a part of the averment, he shall specify so much of it as is true and material and deny only the remainder. Third mode, where a defendant is without knowledge or information sufficient to form a belief as to the truth of a material averment made in the complaint, he shall so state, and this shall have the effect of a denial. What is the effect if material averments in a pleading asserting a claim or claims other than those as to the amount of unliquidated damages are not specifically denied? They shall be deemed admitted. Section 11, Rule 8. These are judicial admissions. Petitioner filed an action for quieting of title against GSIS. The complaint alleged that since 1968 until the time the complaint was filed, GSIS never exercised its rights as a mortgagee. The real estate mortgage over his property constituted a cloud on the title. GSIS' right to foreclose had prescribed. In its answer, GSIS assailed that the complaint failed to state a cause of action and that prescription does not run against it because it is a government entity. Petitioner argued that GSIS had judicially admitted that its right to foreclose the mortgage had prescribed because of its failure to specifically deny the paragraph in the complaint to that effect. Is the petitioner's contention correct? The answer is no. It must be remembered that conclusions of fact and law stated in the complaint are not deemed admitted by the failure to make a specific denial. This is true considering that only ultimate facts must be alleged in any pleading and only material allegation of facts need to be specifically denied. A conclusion of law is a legal inference on a question of law made as a result of a factual showing where no further evidence is required. The allegation of prescription in petitioner's complaint is a mere conclusion of law. Labeling an obligation to have prescribed without specifying the circumstances behind it is a mere conclusion of law. The fact that GSIS had not instituted any action within 10 years after the loan had been constructed is insufficient to hold that prescription had set in. Thus, even if GSIS denial would not be considered as a specific denial, only the fact that GSIS had not commenced any action would be deemed admitted at the most. This is true considering that the circumstances to establish prescription against GSIS have not been alleged with particularity. In fine, this was no judicial admission on the part of GSIS with regard to prescription because treating the obligation as prescribed was merely a conclusion of law. It would have been different if petitioner's complaint alleged details necessary to determine when GSI's right to foreclose arose, that is, date of maturity and whether demand was necessary. Mercine versus GSIS, January 10, 2018. Capital Motors filed a complaint for a sum of money against Yabut. A copy of the promissory note upon which the action was based was attached to the complaint. The complaint alleges that Yabut defaulted in the payment of the note. Yabut filed an answer in which he admits the paragraph regarding his personal circumstances, but specifically denies the rest of the allegation for want of knowledge or information sufficient to form a belief as to the truth thereof. Capital Motors moved for a judgment on the pleadings in its favor should the trial court grant the motion. Yes, the third mode of specific denial may not be availed of when the facts as to which want of knowledge or information is claimed is so plainly and necessarily within the defendant's knowledge that his averment of ignorance must be palpably untrue. The defendant must aver positively or state how it is that he is ignorant of the fact alleged. Capital Motors versus Yabut. Plaintiff sued defendant corporation for non-payment of hospital equipment delivered to it. Paragraph 6 of the complaint stated that defendant's total obligation as of February 15, 2009 was 123 million 901,650, but its balance thereafter became only 54 million because it had since then paid 67,357,683 to the plaintiff. The defendant, in its answer, denied paragraph 6 of the complaint for lack of knowledge or information sufficient to form a belief as to the truth of or falsity thereof, inasmuch as the alleged transactions were undertaken during the term of office of the past officers of defendant corporation, subject to its special and affirmative defenses. The defendant, in its answer, raised the special and affirmative defenses of lack of personal jurisdiction, improper venue, list pendants, and form shopping. Was the manner of denial effective as a special or specific denial? The answer is no, considering that paragraph number 6 of the complaint averred matters that the defendant ought to know or could have easily known. The answer did not specifically deny such material averment. It is settled that denials based on lack of knowledge or information of matters clearly known to the pleader or ought to be known to it or could have easily been known by it are insufficient and constitute ineffective or sham denials. That the defendant qualified its admissions and denials by subjecting them to its special and affirmative defense of lack of jurisdiction over its person, improper venue, litis pendentia, and form shopping was of no consequence because these affirmative defenses, by their nature, involved matters extrinsic to the merits of the plaintiff's claim and thus did not negate the material averments of the complaint. Fernando Medical Enterprises versus Wesleyan University Philippines Incorporation, January 2016. What is a negative pregnant? What is the effect of a negative pregnant? A negative pregnant is a denial of a fact alleged with some qualifying or modifying circumstance, which denial is ambiguous or conjunctive. That is, it cannot be ascertained whether it is the fact or only the qualification or modification which is denied. The effect is that the defendant is deemed to have only denied the qualification or modification, but not the fact itself, which is deemed admitted. Give an example of negative pregnant. Paragraph 4 alleges that defendant bumped plaintiff car while under the influence of alcohol. The defendant denies bumping plaintiff's car while under the influence of alcohol. The defendant is deemed to have denied only the fact of being intoxicated, but is deemed to have admitted the bumping. Plaintiff Galdofa filed a case against Nibon Singh for recovery of possession of, and to quiet title over a parcel of land. Plaintiff in paragraph 4 of the complaint alleges that plaintiff was unable to take possession due to unwarranted adverse claim of ownership and possession by defendant, alleging sale by a certain fee, Nicholas, of subject property to defendant. In paragraph 3, in his answer, the defendant alleged, thus, defendant specifically denies paragraph 4 of the complaint, the truth being that defendant never asserted title of ownership to the property in virtue of any deed of conveyance executed in favor of defendant by Fay Nicholas, nor claim any possessory right. The plaintiff moved for judgment on the pleadings. Should the court grant the plaintiff's motion? Yes. Paragraph 3 of the answer was a negative pregnant. The defendant's denial to the material averments in paragraph 4 conjoined with his disclaimer of dominical or possessory rights in the manner alleged in the complaint. The defendant's denial is therefore a negative pregnant, which is equivalent to an admission. The defendant is deemed to have denied only the qualification regarding the sale by Fay Nicholas, but not the fact that he prevented plaintiff from taking possession by an unwarranted adverse claim of ownership. Hence, a judgment on the pleading is proper. Hey, we'll have more examples of Rule 8 on the next upload. Thank you so much for your support. Give us a thumbs up and subscribe to our channel. We can do this together. Thank you.